A treatise on bill of exchange. Part first, the right acquired by bills. Chapter 1. The general nature, utility, and history of bills of exchange. A bill of exchange is defined by Mr. Justice Blackstone to be an open letter of request or an order from one person to another desiring him to pay on his account a sum of money therein mentioned to a third person. It is consequently an assignment to a third person of a debt due to the person drawing the bill from the person upon whom it is drawn. In other contracts and securities, there are generally only two parties, or at most, a third as a guarantee. Whereas, on account of the assignable quality of a bill of exchange, there may be and usually are many more parties severally liable for the performance of the contract. The person who makes or draws the bill is termed the drawer. He to whom it is addressed is, before acceptance, called the drawee, and afterwards the acceptor, the person in whose favor it is drawn, is termed the payee, and drawee, and afterwards the acceptor, the person in whose favor it is drawn, is termed the payee. And when he endorses the bill, the endorser and the person to whom he transfers it is called the endorsee or holder. Though this security is entitled to a peculiar privilege, yet it is to be considered as a simple contract debt in the course of administration, which an executor or administrator cannot discharge until after satisfying debts by bond without being guilty of a divestiture. And for the same reason, a bill of exchange is considered as following the person of the debtor, and as bona fide notabilia, and I'll slaughter the French and Latin that's in here, so forgive me for that, where he resides at the time of the creditor's death, whereas a bond or other speciality is bona notabilia, wherever it may be at the time of such death. And though a bond or banknote may be delivered in the prospect of death and be a good donation, mortis causa, bills of exchange, promissory notes, and checks on bankers seem incapable of being the object of such donation. A bill of exchange also being merely a simple contract, it is affected by the statute of limitations and must be sued for within 6 years after it is payable. And being a chosen action and a mere security for a debt, it is not to be considered as goods and chattels, and it therefore does not pass by a bequest of all the testator's property in a particular house, though banknotes would have passed, they being quasi-cash, and upon the same principle, a banknote or bill cannot be taken in execution or as a distress for rent, and the accepting of a bill or note in satisfaction of a specialty debt or demand for rent at most only suspends the remedy on the former security and does not entirely defeat it. A bill of exchange is a security originally invented amongst merchants in different countries for the more easy and safe remittance of money from the one to the other, and has since been extended to commercial transactions in this kingdom. The instance put by Mr. Justice Blackstone of the utility of the instrument is this: if A lives in Jamaica and B, who lives in England, £1,000, If A lives in Jamaica and OB, who lives in England, £1,000, now if C be going from England to Jamaica, he may advance B this £1,000 and take a bill of exchange drawn by B in England upon A in Jamaica and receive it when he comes thither. Thus, B receives his debt at any distance of place by transferring it to C, who carries over his money in paper credit without the risk of robbery or loss. In the origin of bills of exchange, it is probable that their principal utility was the safe transfer of property from one place to another, but since the great increase of commerce, they have become the sign of valuable property and equivalent, hold on, equivalent to species, enlarging the capital stock of wealth in circulation and thereby facilitating and increasing the trade and commerce of the country. The trader whose capital may not be sufficient to enable him to pay ready money for the commodity which he purchases on account of his not having the means of immediately obtaining payment of the debts due to him from others, and who might find a difficulty on his own individual security to purchase goods or obtain money for the purpose of his trade, by drawing a bill on one of his debtors payable at a future period, may obtain the goods on money on the credit of such bill. The vendor of the goods to whom the bill is handed as a security may also in his turn obtain goods or money in the way of his trade on the credit of the bill, and the bill may have the same effect in different persons' hands, to whom it may be transferred by endorsement or otherwise. This security is preferable to many others of a more formal nature, for each of the parties to a bill, by simply writing his name upon it, either as drawer, acceptor, or endorser, guarantees the due payment of it at maturity, and the consideration in respect of which he became a party to it can be rarely inquired into, whereas in the case of a formal guarantee, the statute against frauds requires the consideration to be expressed, and other matters of form, which frequently render an intended guarantee wholly inoperative. So, with respect to interest, it is a better security than a bond, for when the principal and interest in a bond equal the amount of the penalty, the interest must thenceforth cease, for the obligor in a bond is not answerable in the whole beyond the amount of the penalty. From the circumstances also of the exposure of the contract to the public eye, there is a stronger stimulus on every party to a bill to take care that it be duly honored, whereas punctual payment of a guarantee or bond is not so frequent, and consequently less to be relied on in commerce, where certainty is so essential to the welfare of the merchant. There are, however, some disadvantages accompanying this security compared with others, and principally that is in case of the dishonor of the bill by the person on whom it is drawn, the holder must immediately give notice of the non-payment to all the other parties, or he will lose the benefit of his security. Whereas in the case of a guarantee, such nice and exact conduct on the part of the creditor is not in general requisite. Again, in case of death, a bill of exchange, being a simple contract, is not entitled to the same priority of payment out of the assets of the deceased as a bond, nor is there the same expeditious or extensive mode of obtaining payment, as in case of a bond, warrant of attorney, statute staple, or statute merchant. The pernicious effect of fabricated credit by the undue use of excuse me here, I'm gonna blow this up, of accommodation bills of exchange drawn out of the ordinary course of trade have been too much felt to require any observation. The use of them, where there is no real demand subsisting between the different parties, is injurious to the public as well as to the parties concerned in the negotiation, unless in cases where, from some sudden and unexpected event, a particular branch of commerce may be affected, and the trade unable to bring his commodities to a fair market in time to meet the payments for which he has to provide. In these cases, by the temporary assistance of friends through the medium of bills of exchange, his credit may be saved, and he may be enabled to hold his goods till some fair opportunity of sale presents itself. The use of fictitious names to bills has not been unfrequent, but this practice is not only censurable, but in some cases punishable criminally. Peculiar properties of bills. The various advantage which commerce derives from the use of bills of exchange have induced our courts of justice to allow them certain peculiar privileges in order to give full effect to their utility. These are, first, that although a bill of exchange is a chosen action, yet it may be assigned so as to vest the legal as well as equitable interest therein in the endorsee or assignee, and to entitle him to sue thereon in his own name. And secondly, that although a bill of exchange is not a speciality, but merely a simple contract, yet a sufficient consideration is implied from the nature of the instrument, and its existence, in fact, is rarely necessary to be proved. The first of these privileges is of most essential importance in various points of view, and principally that our release that a release by the drawer to the acceptor, or a set off or cross demand due from the former to the latter, cannot affect the right of action of the payee or endorsee, because the legal and not the mere equitable interest is vested in such payee or endorsee, and the action is sustainable in his own name, whereas suits upon bonds and most other chosen actions must be in the name of the original obligee. And though it be apparent that he sues merely as a trustee for another to whom he has assigned his interest, yet a release from him or a set off due from him to the obligor may be an effectual bar to the action. The second of these privileges is also of great importance. In general, an action cannot be supported upon a contract not under seal, without alleging in pleading and proving on the trial that the contract was made for a sufficient consideration. But in the case of bills of exchange, promissory notes, a sufficient consideration is presumed, and the validity of the bill cannot in general be disputed on account of want of sufficient consideration when it is in the hands of a third person who has given value for it, as it may tend to elucidate the properties of bills of exchange and other negotiable instruments of that nature. We will shortly examine the doctrine relating to the assignment of chosen actions and the necessity in general for a sufficient consideration to give effect to a contract. The first peculiar privilege of bills of exchange is its assignability, quality, and which is in direct opposition to a very ancient rule of law, the founders of which refused to sanction or give effect to the transfer of any possibility, right, or any other chosen action which is defined to be a right not reduced into possession to a stranger on the grounds that such alienation tended to increase maintenance of litigation and afford means to powerful men to purchase rights of action and thereby enable them to oppress indigent debtors whose original creditors would not perhaps have sued them. Our ancestors were so anxious to prevent alienation of chose or rights in action that we find it enacted by the 32H8C9, which it is said was a affirmance of the common law that no person should buy or sell or by any means obtain any right or title to any manors, lands, tenements, or hereditaments unless the person contracting to sell or his ancestors or they by whom he or they claimed the same had been in possession of the same or of the reversion or remainder thereof for the space of 1 year before the contract. And this statute was adjudged to extend to the assignment of a copyhold estate and of the chattel interest as a lease for years of land whereof the grantor was not in possession. At what time this doctrine, which it is said had regulations originally only to landed estates, was first adjudged to be equally applicable to the assignment of a mere personal chattel not in possession. It is not easy to decide. It seems, however, to have been so settled at a very early period of our history as the works of our oldest text writers, and the reports contained numberless observations and cases on the subject. Lord Coke says that it is one of the maxims of the common law that no right of action can be transferred because under the color thereof pretended titles might be granted to great men whereby right might be trodden down and the weak oppressed, which the common law forbiddeth. Accordingly, we find that judgment was arrested in an action on a bond conditioned for the performance of articles of agreement, which contained a covenant that the defendant should assign certain bonds to the plaintiff for his own use, on the grounds that such condition and covenant amounted to maintenance. And although it was decided that the king, in respect of his prerogative, might transfer a right of action, yet it was afterwards ruled that his assignee had no such power. This doctrine, however, strictly adhered to in our courts of law, was not adopted by our courts of equity. For though it is said to have been decided on the 11th James 1st, that the assignee of a covenant could not sue in a court of equity to enforce performance because it was against law to assign a covenant. Yet that seems to be an insulated case, and no other authority is to be found where a court of equity has refused to give effect to the assignment of a chosen action, provided such assignment were made for a sufficient consideration. A court of equity having it in its power to decree accordingly to the justice of every case, there could have been no danger of maintenance being increased by its given effect to such assignments. We therefore find a great number of cases where decrees have been made in favor of such assignees. In courts of law, the equitable interest of assignees of a chosen action seems to have been recognized as far back as the middle of the last century, when we find it said by one of the judges that if an assignee of a chosen action have an equity, that equity should be no exile to the courts of the common law. In other cases, also, the courts speak of assignment of an apprentice or an assignment of a bond as things valid between the parties, and to which they must give their sanctions, and an assignment of a chosen action has always been deemed a sufficient consideration for a promise. Although the debt assigned was uncertain, so indeed it was decided that where the obligee has assigned over a bond and afterwards becomes a bankrupt, he might nevertheless bring an action on the bond, and that in an action upon a bond given to the plaintiff in trust for another, the defendant may set off a debt due from the person beneficially interested, in like manner as if the action had been brought by the Sestui K trust. But though courts of law have gone the lengths of taking notice of assignments of chosen actions and of giving effect to them, yet in almost every case they have adhered to the formal objection that the action should be brought in the name of the assignor and not in the name of the assignee. The consequence of which rule is that the defendant may give in evidence a release, declaration, or admission of the plaintiff on the record to defeat the action, although it be evident such plaintiff is but a mere trustee for a third person. It has been observed that the substance of the rule being done away, there can be no use or conveyances in preserving the shadow of it. For where a third person is permitted to acquire the interest in a thing, whether he bring the action in his own name or in the name of the assigner, does not seem to affect the question of maintenance. However, in a later case, Lord Kenyon expressed his determination not to sanction the assignment of a chosen action so as to allow the assignee to sue in his own name. The consequence of this doctrine is that if an instrument which is not assignable at law so as to pass the legal interest be endorsed by the person to whom it is payable to his agent to whom he is indebted generally without any specific appropriation, the agent in case of the death of the principal will have no legal or equitable interest in the instrument towards satisfaction of this debt, but must restore it to the executor. Even at the earliest period of our history, the doctrine relating to the assignment of a chosen action was found to be too great a clog on commercial intercourse, and exception was therefore soon allowed in favor of mercantile transactions. It was the observation of the learned and elegant commentator on the English law that in the infancy of trade, when the bulk of the national wealth consisted of real property, our courts did not often condescend to regulate personality, but as the advantage arising from commerce were gradually felt, they were anxious to encourage it by removing the restrictions by which the transfer of interest in it was bound. On this ground, the custom of merchant, whereby a foreign bill of exchange is assignable by the payee to a third person so as to vest in him the legal as well as the equitable interest therein, was recognized and supported by our courts of justice in the 14th century, and the customs of merchant rendering an inland bill transferable was established in the 17th century. In short, our courts, anxiously attending to the interest of the community, have in favor of commerce adopted a less technical mode of considering personality than reality, and in support of commercial transactions have established the law merchant, which is a system founded on the rule of equity and governed in all its parts by plain justice and good faith. Having thus endeavored to point out the peculiar properties of a bill of exchange in respect of its being assignable so as to give the holder a right of action in his own name, it will be proper to make few observations on the second privilege by which it is distinguished from other simple contracts, that of its importing a consideration unless the contrary be shown. Contracts are of three descriptions. First, matter of record. Secondly, speciality. Thirdly, parole or simple contracts. The first of these, the judgment of, the judgment of, or a recognizance acknowledged before a court of record on account of its being sanctioned by such a tribunal, cannot be impeached or the property of it questioned in any action on the judgment, but only by writ of error, nor can there be any allegation in pleading against the validity of a record, though there may be against its operation. Secondly, specialities rank next in point of estimation. These, on account of the deliberate mode in which they are supposed to be made and executed, have always been holden to bind the party making them, although they were executed without adequate consideration, and consequently it is not incumbent on the plaintiff in an action upon a deed to state or prove upon what cause or for what consideration it was made. And though the defendant may be at liberty to avail himself of the illegality in the consideration, it is incumbent on him to state it in pleading and to establish it by evidence. But the third description, namely parole or simple contract, which include as well unsealed written contracts as those which are merely verbal, are not in general entitled to such respect, because the law presumes that such contracts may have been made inadvertently and without sufficient reflection, and therefore, in general, they will not be enforced unless the plaintiff can prove that they were made for a sufficient consideration. It is otherwise, however, in the case of a bill of exchange, it being scarcely ever necessary for the plaintiff to prove that he gave a consideration for it, and the defendant is not at liberty to prove that he received no consideration unless in an action brought against him by the person with whom he was immediately concerned in the negotiation of the instrument, or by a person who has given no value for it. In this respect, therefore, a bill of exchange, although it is not a speciality, yet it carries with it the same presumption of a consideration as a bond or other speciality, particularly when it is in the hands of a third person. It is not, however, owing to the form of a bill of exchange, nor to the circumstances of its being in writing, that the law gives it this effect, but in order to strengthen and facilitate that commercial intercourse which is carried on through the medium of this species of security. For notwithstanding a contract be in writing, it is essential to the validity of it that it should in all cases be found on a sufficient consideration, unless the writing from its being of the highest solemnity imports a consideration or unless it be negotiable at law and the interest of third persons are involved in its efficiency. Having endeavored to state two of the most peculiar properties the of a bill of exchange, namely its assignable quality and its validity in the hands of a bona fide holder, though made without consideration, it may be proper to inquire consciously into the history, general nature, and use of these instruments. Bills of exchange are foreign or inland. Foreign, when drawn by a person abroad upon another in England, or vice versa, and inland when both the drawer and drawee reside within this kingdom. It seems extremely doubtful at what period or by whom foreign bills of exchange were first invented. The elementary writers differ on the subject. It is said by Pothier, I believe he was a French legal scholar, Esquire, that there is no vestige among the Romans of bills of exchange or of any contract of exchange, for though it appear that Cicero directed one of his friends at Rome, who had money to receive at Athens, to cause it to be paid to his son at the place, and that friend accordingly wrote to one of his debtors at Athens and ordered him to pay a sum of money to Cicero's son. Yet it is observed that this mode amounted to nothing more than a mere order or mandate, and was not that species of pecuniary negotiation which is carried on through the medium of a bill of exchange. Nor does it appear that the commerce of the Romans was carried on by means of this instrument, for we find by one of their laws that a person lending money to a merchant who navigated the seas was under the necessity of sending one of his slaves to receive of his debtors the sum lent, when the debtor arrived at his destined port, which would certainly have been unnecessary if commerce through the medium of bills of exchange had been in use with them. Most of our modern writers have asserted, probably on the authorities of Montesquieu, that these instruments were invented and brought into general use by the Jews and Lombards when banished from their usury in order with the secrecy necessary to prevent confiscation, to draw their effects out of France and England to those countries in which they had chosen or been compelled to reside. But Mr. Justice Blackstone says this opinion is erroneous because the Jews were banished out of genuine in the year of 1287, and out of England in the year of 1290, and in the years 1236, the use of paper credit was introduced in the Mughal Empire of China. In China, other authors have attributed the invention to the Florentines when being driven out of the country by the faction of the Ghibellines. They established themselves at Lyons and other towns. On the whole, however, there is no certainty on the subject, though it seems clear foreign bills were in use in the 14th century, as appears from the Venetian law of that period, and an inference drawn from the Statute 5, Rich 2, St. 1.2 warrants that the conclusion that foreign bills were introduced into this country previously in the year of 1381. The mode of transmitting money from one country to another by means of these instruments being once discovered, the advantages derived from it soon induced merchant universally to adopt it, and from thence it very early grew into a custom which seems to have been judicially sanctioned in this country at a very early period of our history, though no earlier decision relative to the custom can be found than in JAS 1, where it was adjudged that an acceptance raised an assumpsit in law, for the breach of which an action on the case would lie. However, as our courts did not at first conceive it necessary to the encouragement of commerce that this exception to the rule relative to chosen actions should be carried any further than the foreign bills drawn merely for the purpose of trade, we find that formally they would only give effect to bills made between merchant strangers and English merchants. However, it was soon extended to all traders and finally to all persons, whether traders or not. Inland bills of exchange, which are so called because they are drawn and payable in this country, according to Lord Coke, opinion, did not originate at the much earlier period than the reign of Charles II. They were at first like foreign bills, more restricted in their operation than they are at present. For it was deemed essential to their validity that a special custom for the drawing and accepting them should exist between the towns in which the drawer and acceptor lived, or if they lived in the same town, that such a custom should exist therein. At first, also effect was only given to the custom when the parties were merchants, though afterwards extended, as in the case of foreign bills, to all persons, whether traders or not. And even after the general customs had been established, and it had been adjudged that all persons having capacity to contract might make them, a distinction was taken with respect to form between bills made payable to order and bills made payable to bearer, for it was once thought that no action could be maintained on a bill payable to the order of a certain person by that person himself, on the ground that he had only an authority to endorse, and those payable to bearer were at first thought not to be negotiable in any case. These distinctions, however, have long been held to be without foundation, and, on the whole, as observed by Mr. Justice Blackstone, although formerly foreign bills of exchange were more favorably regarded in the eye of the law than inland, as being thought of more public concern in the advancement of trade and commerce, yet now, by various judicial decisions and by two statutes, the 9th and the 10th, and the 3rd and the 4th, inland bills stand nearly on the same footing as foreign, and what was the law and custom of merchants with regard to one and taken notice of such is now by these statutes enacted with regard to the other. Besides inland and foreign bills of exchange, there are two other descriptions of negotiable instruments for the payment of money, viz. Promissory notes and checks on bankers, and which are transferable so as to vest the legal right to receive the money in the holder. Most of the rules applicable to bills of exchange equally affect these instruments, their peculiar qualities, and the law affecting them in particular will hereafter be separately considered. When we come back, we'll be diving deeper into Chapter 2 of the Parties to a Bill of Exchange. Thank you for joining me. Thank you for all your support. We'll try and keep these videos short, sweet, concise, and to the point. Again, forgive me for my mispronunciation of Latin and French words, if you can bear it. And again, take the time to go read this stuff for yourself to ascend of the mind. Thanks for joining me, and we'll see you soon.